Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman.
Pam and Jeff, let's go back to gay rights, which for many people would be Justice Kennedy's legacy. How did he get there? Was this a surprise to people to find him writing opinions, granting gays and lesbians important rights?
I think, his position is kind of consistent with the evolution of the kind of milieu from which he came, the kind of libertarian, Western, socially moderate Republican Party of the 1960s and early 1970s. I think, he has this famous passage in one of his gay rights opinions where he says, times can blind us so that we learn things that prior generations didn't learn. And I think this goes back to Jeff's point that as opposed to some of the justices who had more rigid forms of constitutional interpretive methodology, Justice Kennedy was really somebody who talked a great deal about dignity and about fairness and about the individual. And so if that's what you care about, then it's not a super big surprise that as society changed in pretty dramatic ways, you would change along with it.
I don't have anything brilliant to add to that, other than it was a step-by-step process. I mean, Justice Kennedy's first opinion was in a case called Romer, where the state of Colorado had banned any local law that would give anti-discrimination protection to gay people, and he said that was unconstitutional because you can't make a certain class of people a stranger from the laws. And he kind of worked his way up through these cases, and we all just came to learn that this was something that was important to him.
Although it's interesting that his last gay rights decision is also from Colorado.
That's right.
And is almost the flip side of this, the Masterpiece Cake case, where he essentially, although he still thinks that states can have anti-discrimination laws that protect people against discrimination on the basis of sexual orientation, he's become increasingly concerned with the rights of and interests of conservative Christians, in this case, a baker who didn't want to have to bake a cake for a gay couple that was celebrating its marriage.
And listeners who want to know more about the Masterpiece Cake Shop case can go back and find a podcast that, Pam, you and I did on that decision after it was announced.
That's right. And I think, if Justice Kennedy had retired under different circumstances or had died in office as Justice Scalia did, I think everybody would have been focused on the gay rights cases as his legacy. But I think his decision to retire with this president in office and the country in the kind of polarized position it is now has led people to think that one of his major legacies is going to be the extension of conservative dominance over the Supreme Court for another generation. And it's really striking when you just think about the dates here and the like. So, for example, the Democrats have won a number of the recent presidential elections, but the last time the Supreme Court had a majority of justices who were nominated by a Democratic president was in 1969. And so essentially for the last 50 years, the Supreme Court has been dominated by nominees who were nominated by Republican presidents.
And one of the things you do jurisprudentially and politically, if you look at the court kind of cynically as in part a very political body, is decide when to exit. And that might be one of the most important decisions you make, given our nominating process.
This is Stanford Legal, and today we're talking with Jeff Fisher about the Supreme Court and where it goes from here. Jeff?
Oh, I'll just add to that I think, Joe, you're right. I mean, when you retire, whether you're a Supreme Court justice or anything else, is an intensely personal decision, and I certainly don't begrudge Justice Kennedy or anybody else from once they get to be a certain age of wanting to do that. But I think we have two major contingencies that'll feed back into his legacy. One is how many of his decisions that were 5-4 decisions, most if not all with liberals, will be overturned. And so you can't have much of a legacy if a new court 5 or 10 years from now overturns those decisions. And I think that's likely to happen in some instances. And then secondly, we have this gigantic wild card with President Trump. So he has given the keys to President Trump to name his replacement, and we have just obviously various potentially explosive political circumstances that could bring President Trump and his legitimacy, perhaps even to the doorstep of the U.S. Supreme Court in years to come. And so I think that would be an important piece of Justice Kennedy's legacy as well if it plays out.
So one of the things, Jeff, that I think people focus so much on these high-profile cases. They don't focus on the entire panoply of cases the court has before it. And one of the things that that you've shown a real genius for is cobbling together 5 justice majorities that don't break along traditional lines, particularly in the area of criminal procedure. And I wonder if you might say a little bit about going forward, how you think effective advocates are going to be able to build a win for their clients at the court.
Sure. Well, thanks for saying those nice things.
And they're true. In addition, they have the virtue of being true as well as nice, which is rare.
I mean, in a way, I'll contrast it with Carpenter, because Carpenter was a decision that the Chief Justice wrote in kind of what the public tends to think of as in the classic constitutional mold from when you have more liberal outcomes, which is him saying, look, we have this Fourth Amendment guaranteeing a right to privacy, and if that guarantee that the framers gave us is going to have a meaning, true meaning today, we have to extrapolate from the purpose of that right and apply to new circumstances today. And so that's the mold at which lots of victories from the left have been made, and there's a big debate over whether that's valid or invalid as a matter of living constitutionalism. But what I've done in some of these criminal procedure cases is actually flip that on its head, because what you've found over recent years is, starting perhaps most dramatically with the war on drugs and Chief Justice Rehnquist's tenure, the court cutting back on various historical and textual protections for the accused on the ground that the evolving circumstances of modern times requires greater prosecutorial power. And so using all the conservative tools that have been used to fight back against other forms of living constitutionalism, I have argued to the court and put together majorities of conservatives on the one hand, who look at the original understanding and history of the Constitution, along with liberals concerned about the rights of the accused, to hold that these historical provisions in the Bill of Rights have to be enforced vigorously today, notwithstanding whatever prosecutorial necessity arguments might be put in front of the court.
Well, when we talk about Justice Kennedy's legacy, it's kind of a complicated one. He was conservative in some areas, liberal in the other. On his liberal decisions, they're 5-4. And the real question is, what happens next? And I guess we'll have to have you back on the show next year, Jeff,
well, we'll see.
To talk about this with Pam then.
Right. I mean, we'll see. To pick up what I was just saying, I kind of some of my early cases were notable for being able to get to 5 without Justice Kennedy, and so maybe some people will be looking at that more in various ways now.
Well, you'll certainly have to get to 5 without Justice Kennedy if you're trying to get a majority on the Supreme Court. So thank you so much, Jeff, for joining us, and thanks to our listeners for joining us here on Stanford Legal, here on Sirius XM Insight 120.